Hey, everybody, it's Eric alongside Rod here to welcome our distinguished guest, University of New Hampshire School of Law professor Michael McCann, who is the founding director of the Sports Entertainment Law Institute and former associate dean for academic affairs. Professor McCann specializes in teaching IP and antitrust law revolving around sports and NIL. He's testified before Congress and serves as a legal expert on many media sites. You'll see him all over the place. McCann has served on the legal team in the Maurice Clarett versus NFL case. All that is in addition to a list of accolades. That's frankly just too long for me to list here on our podcast. Needless to say, Professor McCann is something of an expert when it comes to athletics and the law. To follow what he's thinking, working on, you can follow him on X at Michael McCann, or you can check out his work at sportico.com, where he's a frequent contributor. So, Professor, thanks so much for joining us in the Final Fours on the schedule.
Hey, thanks for having me.
Yeah, our pleasure. I think it's probably easiest for in this discussion to defer to the attorneys. So I'll let Rod kick us off here.
Thanks again for joining us. And just as an aside to our listeners, a lot of what we're going to be talking about, obviously, is going to be focused on the intersection between collegiate sports, its structure, the compensation and definition of student athletes, and the law. And if you're looking to stay updated and get really meaningful insight into these issues and how they're continually evolving, I can't recommend highly enough following Professor McCann's Twitter account. It's in my opinion, it's the best commentary out there. I've been following his account for many years and never fails to offer keen insight. So I wanted to start with what Eric touched on in terms of your background, because in my mind, you've had involvement with perhaps the two key cases in different ways that kicked off this modern era in the intersection between what I was just talking about, collegiate athletics, amateurism, and the law. First, I wanted to start with Maurice Clarett. So that's to refresh people's memory. That's the former Ohio State running back. And his case concerned draft eligibility in order to be able to be drafted into the NFL. And you were involved in representing him. First, I'm curious because if I've got it correctly, that happened very early in your legal career. How did you become involved in that case?
Yeah, and thank you both for the nice words. I became involved in that case because when I was in law school, I wrote a law review note on players who wanted to go from high school to the NBA. If you remember back then, the NBA allowed it, and there were talks that the NBA would ban high school players.
Right.
And I wrote a note looking at the antitrust implications. I argued against it. I argued that players should be able to go directly from high school to the NBA. And it was published. And as you both know, academic works don't always get much attention. My brother read it. My mother said she read it. I don't think she did. And that was it. Like, it was there. And then the Clarett case came 2 years later, and my brother said to me, his older brother, he goes, "Why don't you send Clarett's lawyer your note?" And I said, "Well, why would he even look at it? Like, I mean, I'm just some random lawyer in Boston." And, well, I sent it to him. Alan Milstein was a lawyer, and that led to a conversation where I joined the legal team. So I always tell my students, I like to pretend that I was athletic or charismatic or something, but regrettably, none of those things are true. But I did write, and that got me into sports law. So that's how I got into that case.
Yeah, very, very interesting. I a century ago, actually 30 years ago, but close enough, I took a sports law class when I was in law school. And I recall at the time, so this is 1994, the feeling I came away with was, well, if this was ever challenged, and specifically NFL draft eligibility we're talking about, that's a winning case. But that the problem would be finding a plaintiff who was willing to see it through, because as we know, the wheels of justice tend to turn slowly. And by the time a plaintiff would actually be in a position where their case was being heard, the prohibition against their eligibility would likely be extinguished. They would then be eligible because they were old enough. That was always, it seemed to me, the NFL's get out of jail free card, was that nobody would be willing to stick through until the end. What was different about Maurice in your view?
Yeah. We so mindful of the point you just made. We sought an injunction to restrain the NFL from being able to apply this rule, and the district court judge granted it, and then the NFL got an expedited appeal to the Second Circuit, and we lost there. But that was obviously a big hurdle, as you said, because the age limits have such a short duration relative to other things in the world that you have to act swiftly and get a restraining order is the only way to do it. And then by the time you hope it lasts long enough so that the draft comes and the player's in, and then it's a moot case and you've won. That was the thinking on that, and also it wasn't collectively bargained. I mean, this was the other part of the case that nowadays these rules are all collectively bargained, so it's profoundly difficult to challenge them. But that rule wasn't, and although the Second Circuit sort of punted on that question, it was not in the collective bargaining agreement. It was referred indirectly, but it was not in the CBA. So that was the other reason we thought we had a good shot. And I really think we should have won that case, but obviously not neutral.
I know, but I agree. I mean, as I say, I recall even a few years before this case was filed coming to the same conclusion based on the readings we did in that class, that it seemed obvious to me, and the only question was going to be, do you find a plaintiff who's willing to actually go through with it? The other case you had involvement with from a different perspective, I think, that's maybe got an even more profound effect on the rest of what we're going to be talking about today, is your involvement with Ed O'Bannon, the former UCLA basketball player. And if I got this right, you wrote a book with Ed, right?
Right.
Detailing the journey that he went through in his case, which really turned on, and I'll use this generally to describe it, a term that's very familiar to people now, name, image, and likeness rights. And specifically, it involved the use of those in a video game, correct? That was the central point of that case. I'm curious. I can understand why you would have been involved because you'd had the experience of going through the Clarett case, but was that the major reason you got involved in writing that with him, or was there another connection that brought you to that?
No, and you summarized it perfectly. That was one of these cases where I was there at the trial, and so I wrote for Sports Illustrated along with Stuart Mandel and Andy Staples. Basically, I think we each took a week there, and we wrote about the trial. And through that, I got to meet Ed as part of that process, and had a good conversation with him. And it's sort of, we just continued the conversation thereafter. And that was really the genesis of that. And I also just thought, this was a case where you could explain it to somebody that's not a lawyer and they get it, right? Why are these players in video games without their consent, without their permission? There's something wrong about that. Like, it just hits people as, that's not right. This game sells for $60. It's relying on players, most of whom never made any money playing college, pro sports, most including Ed's teammates, right? Very few of them ever went pro. So I think it struck a chord. Now, obviously, things going on today are gone way beyond that, but I think this case really kind of revealed the NCAA's position as unfair, maybe even immoral, honestly. And I think that also attracted me to it.
Yeah, absolutely. You just kind of touched on something where we've gotten today versus where we were back then. At the time that your involvement in these two cases was unfolding, did you, if you gave yourself a second to think about it, did you think that we were starting on a path leading us to where we are now in 2024? Or would it have surprised you 20 years ago, 15 years ago, to know where we are today?
It would surprise me. It would surprise me. And I say that because I certainly envisioned a world where college athletes are treated like other college students, right? That's really what O'Bannon wanted, that if somebody uses your identity, you get paid for it. You can do an endorsement. If you're a college singer, if you're a college actor, if you're marketable in some way, you have a right, under the right of publicity, as you know, to profit from it. It has gone into a direction that I didn't foresee, at least to the degree in which it's occurred. I think NIL has really morphed into another version of pay for play, which is there's certainly an argument that players should get compensated, and I totally get it. But the NIL, what's NIL? I think the definition of that is essentially, at least in some cases, especially involving collectives, I think that it's gone. I think it just is another vehicle to
Yeah.
recruit athletes. So did I expect that? I mean, collectives? I don't think anybody was talking about collectives until the collectives came. I don't remember. I mean,
Right.
booster was a phrase, but collectives was this new thing. I didn't foresee that.
Okay. Well, turning to a couple of cases that are in the news a lot lately, particularly the first one I want to ask you about. We've just been living through Supreme Court decision season over the last couple of weeks. And it seems to me, and I honestly had not been thinking about the implications of this one related to collegiate athletics until I read an article that you wrote. So I want to talk about the if I got this right, the Loper Bright case.
Yep.
Which, just to give our listeners a very general description, the upshot of this ruling by the Supreme Court is that we're no longer giving deference to federal agencies in terms of their interpretation of statutory law, which had been something that was done based on the Chevron case, heard what, about 40 years ago, I think. We've been
Yep.
living in that world. So why does this particular ruling have implications for issues regarding compensation of student athletes, and more particularly their potential status as employees? And the obvious case that you think about as an example here is what's going on with the Dartmouth men's basketball team and their quest to be defined as employees, and how that might intersect with the National Labor Relations Board and all of that. If you could just take a second and walk us through how you think this ruling impacts all of that.
I think it creates less certainty, not necessarily in a way that favors one side or the other, but it does suggest that the National Labor Relations Board, particularly when interpreting who's an employee, which is actually not a clear answer. The law has been called circular as to who counts as an employee. Judges have a pretty good deal of discretion in applying different factors. I think that it would always wind up in court, that question, and I think eventually the Supreme Court will probably address that issue, not anytime soon, but to me it ends there, one way or the other. But the NLRB is clearly going to have an instrumental role in this, in interpreting the National Labor Relations Act as to whether or not the players are employees. And this decision, sort of looking way above, this decision suggests that the NLRB may not get the same degree of deference that it would before. Now, people are going to say, well, wait a second, they probably weren't going to get the same deference because this is such it's a major question. And major questions, courts are less likely to apply Chevron anyway. So that's true, but I think what it does mean is that the final answer of who's an employee I think will be by the courts. It will not be by a federal agency. And that doesn't necessarily benefit one side or the other. Right now, the NLRB, I think, would be poised to find that they are employees. But there's an election coming up. If there's a change in the administration, there will be a different NLRB, a different general counsel. So it doesn't necessarily cut one way or the other. The other way I think this decision is going to be impactful is at the FTC level, where the FTC is thinking about banning non-competes. There's talk that the FTC could regulate agents for college athletes. These are issues also where if the agency comes up with regulations, they could be subject to more scrutiny. The test is whether or not there's ambiguity in the law itself. That's where Chevron kicked in, that there has to be something ambiguous and that the agency interpreted it. Whether that fact pattern follows here remains to be seen. But to me, I think the big picture is courts are more likely to have final say than agencies.
And so that obviously has an inherent unpredictability. Relative, it's easier for us to have a pretty good idea of what an agency's view is. So then I wanted to turn to the other recent case in this area that's gotten a lot of attention, and that's the House case. And as I understand it, there are actually several antitrust cases that were all sort of brought together in this proposed settlement, correct? But we're using House as the overarching descriptor. so again, please correct me, augment my answer if I've got it wrong. As I understand it, there's essentially what amounts to a term sheet that's been agreed to by the NCAA, the power conferences, and the attorneys for the litigants, for the players, to settle these cases. So we're not even to a full-fledged settlement yet. And once we get there, the court's got to approve it. And the basics here are that players would receive compensation directly from the schools, which is something that a lot of people have been asking for, believe is legally a correct way to go, morally a correct way to go, that would finally happen, which would essentially give up the charade of amateurism that we've been living with for decades and impose some sort of pay for play structure. One that's more direct than the NIL version we've got right now that you described a few minutes ago. If I'm reading you correctly, it seems to me that the NCAA has, in the wake of this, has seemed to take the position, or at least attempt to convince people, that this case being settled really wraps up their issues in these areas, or you could get that impression. I've sensed that you're very skeptical of that. Can you walk us through the reasons why you don't believe House is the end or even the beginning of the end of upheaval in college athletics? And in particular, I'm struck by the way you've talked about the fact that the lack of collective bargaining alone may prove to be the reason why this isn't the end of their issues.
Yeah, no, you summed it up perfectly, I think. I mean, there's several reasons why I don't think this is the end. One is, as you said, they have a settlement term sheet. Let's see if there's an actual settlement, and let's see if the judge approves it. We've already seen Houston Christian University object to this. We might see other schools object. The colleges have said we're not actually defendants in this case, and yet we're being subject to the terms in terms of having to pay money through not getting money, essentially, is how that works. So there's already questions of whether there will be objections. We also know that judges sometimes reject settlements when they're too far reaching. That happened with the Google digital book settlement, where Google reached a deal with authors and others connected to books that had been digitally reproduced without their consent. They had a deal. The judge said, no, you don't. This is too far reaching. There's several other concerns with it. So there are a lot of hoops before we're even at the end point. But then at the end, there's, let's say there is this deal and it goes forward. There are still questions remaining. One, as we talked about, are college athletes employees. That's a huge question that's not resolved by this settlement. And that will lead to all sorts of implications for colleges and maybe conferences and the NCAA as well if they're joint employers. This settlement doesn't address that. This settlement doesn't address the fact that there are other cases, antitrust cases. This would have to be a national settlement that includes everyone, at least everyone in Division I. That's not what this settlement is, at least as it's currently configured. So there could be other antitrust, and there are other antitrust cases that are not resolved through this settlement. Then there's the prospect of the fact that none of this is collectively bargained. So what does that mean? It means there's no exemption from antitrust scrutiny. The benefit, this is why, as we know, pro leagues usually avoid litigation, because everything they do is agreed to by a players union. Well, there's no players union here. And maybe there will be eventually, but there isn't one right now. So everything is subject to antitrust attack. It doesn't take a lot of imagination to think that there are antitrust players out there that will challenge what amounts to a salary. This is a salary cap system, right? It's 21 billion.
Yep.
This is a pro league without being born through collective bargaining. To me, that's a recipe for being challenged by people who are outside the settlement. And I just don't think it ends the story. And there's so much litigation. There's such an incentive to sue that it's hard to imagine that this is the end.
Yeah, I agree. And just as a quick follow-up on that, the more that I've read about all of these things and thought about it, it has seemed to me that collective bargaining ultimately has to be part of the answer to solve this stuff for exactly the reasons you suggest, because nothing else, we've had Jay Billis on our show last summer and just within the last few weeks. And I recall last summer, he had offered, which I had never thought about, the idea that, well, you wouldn't even necessarily need to have collective bargaining to come with a solution that worked, because the institutions themselves could just contract the way that anybody can privately contract. But the more I've thought about it, the more I think there's still a vulnerability if you don't have collective bargaining shielding you from the implications of antitrust. Would you agree with that? And in your view, do you think that's a necessary component of what will truly solve these problems?
Yeah, I think it's certainly the easiest way of doing it. I mean, Jay is right. There could be independent contracting, and I just think the administrative sort of complexity of that, and what will there be one contract for every player? Do schools want to get into a world where they're doing one-off negotiations with athletes? I mean, maybe, but I think it gets tricky. There's also, of course, Title IX that would expose some of these contracts if if the net result isn't equitable in terms of sex. So, yeah, I mean, to me, the benefit of collective bargaining is that it's easy in the sense that you get a set of rules, right? And they
Right.
govern everyone, and everyone agrees to play by them. The alternatives, there are alternatives, but they wouldn't create antitrust immunity. And they're also complicated. And honestly,
Yeah.
I think what schools don't want right now is a complicated world. I think they already feel like this world,
Yeah.
right? It's like it's already a huge source of pressure on them and uncertainty, right? They don't know what the rules are. They don't know what the rules are going to be a year from now. I think what they want is clarity and collective bargaining, if nothing else, it provides clarity.
Yeah, the guardrails that we continually hear about. That one more quick follow up on that, and then I'll finally stop talking and turn it back to Eric. Um, we you mentioned at least tangentially antitrust exemption, and I have seen it speculated that the NCAA's long game around House involves getting this case settled and then turning to Congress and saying, you need to give us an exemption from the application of antitrust, which, as I don't need to tell you, baseball is the only sport that actually has that formally. Uh, do you think there's any chance of that happening? I just, to me, I see no reason to believe that that's likely. I don't see the groundswell for that, but maybe I'm missing something.
You and me both. I don't see the groundswell either, and I don't see the audience for it. This isn't as
Right.
if this is right. I mean, both parties have been critical of the NCAA, maybe for different reasons, but they've both been pretty critical of the NCAA. This is not a popular entity, and Charlie Baker is a new face, and he's a former governor, of course, and the polarization of Mark Emmert is gone. So that probably gives the NCAA some running room. But I don't see, I mean, the idea of giving any industry an antitrust exemption doesn't strike me as particularly popular this day. And also, why would the NCAA, an entity that has violated antitrust law a number of times, according to courts, why would we give them a break? If anything, if
Right.
they should be scrutinized more carefully. So
Yeah.
it's hard to think that they're a deserving recipient of an exemption. Now they're going to say, well, look, we're now paying players. We've created this pro league effectively. Oh, okay, I get that, but then just bargain with them like the pro leagues actually do. I mean, so yeah, I mean, maybe there's this groundswell that we're not seeing. I haven't heard of it. I don't know who's leading it. That to me is I would be worried if I were the NCAA.
Yeah, there's a as everything with the law, there's a lot of I guess lack of clarity. And that's why we have to bring the lawyers in to try and explain all these things. Clear as mud, as they say. Maybe your windows are clear as mud of your house. Make sure you check out the Squeegee Squad of Grand Rapids. They can make sure everything's nice and clean. If you mention Final Four, you get 15% off your estimate. You can find that at the support page of the Final Four, on theschedule.com/support. Also, one reminder, it is summer. There's thunderstorm season, or I guess out, as you would say, out in the Northeast, wicked storms. And so if you have those problems, you want to make sure you've got good gutter work. The brothers that just do gutters can take care of all that. 10% off. You mentioned Final Four. They can replace, repair, put those leaf guards on, whatever it is that you are tired of dealing with at your house. Make sure you got good water control. You had mentioned a little bit there about Title IX and sort of the implications also involved in this. And that's something we've sort of touched on it before. But how do you think the direct compensation in Title IX, what sort of, I guess, implications you see there as far as problems that the universities may face if they don't have some larger, entity governing that?
Yeah. So if colleges are the direct payer under what's understood as Title IX now, now maybe there will be reforms to it, I don't know, but a world where there's a salary cap of say 21 million, I don't see a way of a college paying players that basically pays the football team and some money goes to men's basketball and a little bit goes to women's basketball. That world does not seem possible under Title IX. And I would imagine any school that does that would be subject to Title IX litigation pretty quickly. So what does that mean? It would mean, presumably at the end of this 21 million, that it's shared roughly evenly between men's and women's players, which could be, for women's basketball players, I think, a really good thing. But it could also mean other sports, women's sports, benefit from it. So that is certainly a possibility. I don't see, I don't, people say, well, economically, shouldn't the money go primarily to the football team? Maybe, but that's not what Title IX is, right? That Title IX is not
Right.
about the economics, it's about equity.
Yeah, that's more like it's mainly based. I always felt it was based on scholarships and availability for opportunities at college. Is that so? The compensation be viewed the similar as scholarships? Is that what your contention is?
Well, so they're not. So if they're not employees, it can't be employment, right? So we.
Right.
This is another reason why collective bargaining and having college athletes as employees might help colleges, because they could classify payments as a wage rather than as a benefit related to something academics. But since they're not currently employees other than at Dartmouth, the I don't see how it's distinguished from other benefits going from the school to the student who is an athlete. I mean, it would strike me as falling in the same category. Obviously, this is a new kind of payment, but I don't see what would give it an exemption from the reach of Title IX. Now, if the conference is the payer, this is where it gets really interesting. Conferences haven't been subject to Title IX, and neither has, and the NCAA isn't either. So if the conference or the NCAA is the paying entity, that's a different scenario. But as I understand the settlement, it involves the college as the payer, which I think definitely raises a Title IX issue.
So turning back to more structural issues, there had been this idea floating around in recent years about the power conference schools perhaps opting to leave the NCAA entirely as and form their own governing body, at the very least for football as the major revenue generator, but possibly other sports as well. And it seems to me that talk about this seems to have died down over the past year or so. Do you, as you see it, do you see that as a realistic path for those schools? And we could debate how many of them there actually are, 40, 50, somewhere in there. Do you see that as a realistic path for those schools to take? It's always struck me that one of the main motivations for it might be the fact that their interests are distinct from the vast majority of the rest of the NCAA member body. And so they have different motivations, and that maybe it is the smart move to get out from underneath the NCAA rubric and start making, like, for example, the resistance to defining student athletes as employees. I can understand why a Division III school would be scared to death by that, but maybe it makes sense for a bigger institution. Do you, and then in turn, do you think that maybe that type of move might be a step toward actually solving the various legal and financial issues that these schools are currently facing?
Yeah, that's an interesting question. So it makes me think that it's another reason why the NCAA really wants to do the settlement is that it sort of makes the motivation to spin off away from it for the power schools less necessary, right? Because they can now get this vehicle of directly paying players through a settlement. So I think it's another reason why the NCAA really wants to see this happen, despite it being such a radical shift from what we know about college sports to something that's really, I think, a pro league. It has died down a bit, and maybe it will pick up if the settlement doesn't advance. As you said, Rod, it certainly makes a lot of sense for those elite programs to do their own thing. It also maybe it makes sense for everyone else for them to do their own thing. I mean, there are really, whether it's 30, 40, 45, whatever number of college football programs that it could be. I mean, to me, it sounds like a pro league, right? Look at
Yeah.
major pro leagues got 15 teams in East and the West, or 16, depending upon the league. So it certainly structurally makes sense, and I think there would be a lot of money in it. This brings up a point. I remember in my sports law class, I proposed to them. I said, "Well, why don't we have a world where college football spins off at the major programs, and then they enter into a licensing agreement with the school. So it's still Alabama football, it's still Michigan football. The players could still be students, but they don't necessarily have to be. And the IP is the same because there's a licensing agreement. And I'll never forget how much hostility I got towards that. They hated it. They literally hated that. They said, if it's not part of the school, it's something else. So that, and maybe that's true. Maybe I was underestimating the impact of formally separating the team from the school. But yeah, so Rod, my instinct is that it has died down a bit, but I also read that the private equity wants to get involved. So
Yes.
right,
I'm
so
sure.
there's something going on. Yeah.
So then we'll ask the impossible question. You get your crystal ball out 10 years from now. Is there an NCAA? Where do you see things as far as how players are classified, how they're paid, how the intersection? I mean, is it, as you mentioned, are there college athletics? Is it a totally different sort of structure? What do you think things are going to be like in 10 years? And the nice thing is you can't get this wrong because no one's going to check back in 10 years.
Yeah, I think the NCAA will still be around because I still think it performs a number of functions. It also has a lot of money. It has a lot of heft. I don't see why it would disappear. I think what we'll see is college football and to some extent men's and women's basketball really just separated from, at least at the major programs, separated. I think college athletes will definitely be paid, and I think they probably will be employees, to be honest. I think that somebody asked me that question 10 years ago, are college athletes employees? I would have said, well, you got to look at, I mean, I don't know, they're also students. It's actually not hard to be found to be an employee. I mean, it's really about control. And this is where schools get in trouble. This is where coaches who are sort of dictators, they've totally doomed their schools because they are acting like bosses. It's not about whether the school is even making money on sports. That's not the test. The test is about control. So I think the legal argument for college athletes as employees is really strong. And I think they will be recognized as employees. I think we'll see some schools shift to club sports, particularly as a way of mitigating risk. I think some schools are going to say, this varsity sports model is antiquated. We've been grouped in with these major programs that make all this money. We're not that. And I could see a revival of club sports in a way that could be really interesting and not necessarily bad either. I don't think it means the end of the world for college athletics. It just means that the model of Division I is just too big. There are too many schools in Division I with very different profiles. It's not like the Major League Baseball where every team is rich, every team can do all these things. Division I is way too big in my view. There should be a separate, essentially, league for pro-like teams, and then maybe a more moderate model for others.
Yeah, my wife is a Twins fan. She disagreed that all teams are rich in Major
Sorry.
League Baseball.
Yeah, sorry about that. Maybe baseball's the wrong league. NBA. Let's take NBA.
Yeah. Well, as long as they don't play the Yankees, they're fine. So anyway, we really appreciate you coming on. Is there any particular place people should follow you to besides X Twitter?
Nah, you know, there's go read Sportico. Honestly, don't even read me at Sportico. The stuff on Sportico is so good. The writers are really insightful. They know business inside out. I always learn something reading Sportico. You can skip my stuff if you want. There's so many good. I mean, I'm just the law guy. Like, there's actually really interesting business stuff there that I assign to my students, and I don't know. I would check out that. I mean, I'm biased, but like literally, you learn a lot going there.
All right. Well, before we go, I want to remind everyone I will be at Moneyball on July 11th. You want to stop by, say hi. I think this will still come out before then. Also, check out Nudge Printing at nudgeprinting.com for all your Spartan apparel. Great, great gear there. 20% off if you type in Final Four, just as one word on at checkout. And also the Christian Brothers Automotive Grand Rapids. If you need oil change, mention hoops. You get $40 off your oil change, and it comes a free tire rotation and courtesy inspection. You can find all that stuff at the Final Four is on theschedule.com/support. Again, thanks for Professor McCann for coming on the show. We really appreciate it. We learned a ton. I managed to stay awake for 40 minutes of a legal discussion, so I consider that a victory for me as a as a physician. So until next time, the Final Four is on the schedule. Go green.